Good morning. Oh, it's Miss Alford. I looked up about to say Miss Kukafka, and I looked up and I realized it was a she, so it's Miss Alford. Good morning.
Good morning, Your Honors. Pamela Alford for the Commonwealth. With me is Brian Wilson, who handled this matter at the Superior Court. In this case, over the Commonwealth's objection, a Superior Court judge conducted a guilty plea colloquy, but declined to make a guilty finding or enter it on the record. Instead, the court placed the defendant on probation for 3 years after filing the indictment, after which time the judge anticipated, and there was proceeding under, or the judge anticipated that there be proceeding under Brandano, and if the defendant complied with the probation on an indictment for unarmed burglary, the charge would be dismissed. The Commonwealth objected to this proceeding after the court's, this court's decision in Commonwealth v. Cheney moved for reconsideration and requested there be an entry of guilty and then objected to the eventual dismissal of the complaint in appealed. Because the dismissal of the indictment was not authorized by the legislature and because the indictment was otherwise valid, the judge's dismissal of the indictment over the Commonwealth's objection violated Article 30's dictates regarding the separation of powers. Accordingly, this court should vacate the court's order dismissing the indictment.
Go ahead. Are you saying that the dismissal was bad, or are you saying that it was improper to record the case as a not guilty? You want the guilty finding entered in the record, don't you?
We do, Your Honor, although we do note that pursuant to this court's precedent in the Commonwealth v. Sebastian S., that, we would like the guilty finding entered in the record, that in that case the defendant was given the opportunity to withdraw the admission to sufficient facts in that case. We do note in our brief that that's the procedure the court should file, that the defendant receive an opportunity to withdraw.
But I guess my question is this. If the court had entered a guilty finding and then dismissed the indictment, would you be here?
We would be here because I think, as cited in the defendant's reply brief in Commonwealth v. McCullough, once a guilty finding was entered, the case could not be dismissed. The case could be appealed. But
what's the minimum sentence that a defendant can get on an indictment?
On an indictment, I guess what was suggested in the lower court proceedings would be probation for 1 day.
And then dismissed?
Probation would be terminated after the disposition of the charge.
And then the case would be dismissed?
No, the case wouldn't be dismissed. There would be a guilty finding on the defendant's record. The defendant's probation records in the court docket indicates there has never been a guilty finding. This case was dismissed over the Commonwealth's objection. There was no legally cognizable disposition. By taking the actions the judge did, the judge essentially overrode the Commonwealth's exclusive discretion to prosecute this case.
What you want to do is be able to go to trial against this defendant unless there's a proper guilty plea. That's what you want, right? You want to vacate the dismissal. Yes. And you want to give him the opportunity to withdraw his, I guess you'd call it a tender of a guilty plea.
We think that's appropriate under Sebastian S.
And that would then put the case back in the status of a pending indictment. Unless
the defendant is willing to accept the entry of a guilty finding. That would be what the Commonwealth would like.
Oh, okay. And in that case, if he accepts it, then he's all finished.
Then he's finished.
The probation is over with.
I take it you concede that there's nothing that the judge has done here that's specifically inconsistent with either Tim T. or Cheney. Right? I mean, the judge took a plea.
I would disagree with that. And now the Commonwealth, the judge did not have the benefit of Commonwealth versus Cheney. The judge had retired in the interim between taking the plea and Commonwealth versus Cheney. So the Commonwealth's motion for consideration was before a different judge.
I understand that, but Cheney, we're talking about the judge dismissing a case prior to verdict, finding, or plea. Can't dismiss a legally adequate criminal indictment in the interest of public justice.
Correct.
Prior to one of those things happening, because the Commonwealth is prejudiced. They brought the case. They have a right to essentially get their finding or their plea or whatever it is. And that was done here. There was a plea rendered and accepted.
But never entered on the record. The Commonwealth suggests that the plea is not legally cognizable until the guilty plea is entered on the record. This was a guilty plea.
It helps you in the sense that if something were to happen during the probationary period, you don't have to go to trial.
Theoretically, we don't know that.
Well, I mean, isn't that the point of it?
That was the point of it.
As a procedural matter, how could anyone prevent something from being entered on the record if the defendant stood up and pled guilty?
Because the court ordered, that there was a guilty plea. That she had taken the plea, but there was no guilty finding.
She accepted the plea, directed that the case be filed without a finding, and that he be placed on conditions of probation.
That's correct, Your Honor. And the Commonwealth did move for clarification of that ruling, noting that the docket entry said that the case was filed with no guilty finding entered. In the disposition memorandum, noted that the interest of justice warranted accepting a plea of guilty and placing it on file. And what the judge said, and this is at record Commonwealth Brief 31, the docket entry is correct. So there has never been a guilty finding in this case.
When I looked at this, it appeared to have fallen, to be a situation, I shouldn't say it had fallen, but that doesn't fit any of the cases we've said, about what you can't do before. So you're really looking at the general picture and saying that you've said you can't do this, you can't do this, you can't do this, and that all leads to the logical conclusion that you can't do what occurred here.
I would disagree with that respectfully. I think this case irrevocably follows from Commonwealth versus Cheney and Commonwealth versus Sebastian Ness.
Under the rules of criminal procedure, I take it you cannot have a continuance without a finding in the Superior Court.
Under Rule 28, under judgment, the judge was to.
Can you have a continuance without a finding in Superior Court?
No.
Okay.
The Commonwealth's position is no. That the reason why that a continuance without a finding is not as under Commonwealth versus Powell's. A continuance without a finding was not a violation of the separation of powers because it was part of a legislative enactment, General Laws Chapter 278-18. And what the court said in Powell's was that while the Commonwealth has the exclusive discretion what to prosecute and who to dismiss, the legislature has broad powers in enacting crime, alternative dispositions, and criminal procedures. And under that power, the continuance without a finding disposition as specified in 278-18 did not violate the Commonwealth's, did not violate the separation of powers. So a judge acting under 278-18 accordingly does not violate the separation of powers by continuing a case without a finding. What does violate the separation of powers is to continue a case without a finding without complying with 278-18, which by the explicit terms lists the courts that it is applicable in and does not list the Superior Court. So 278-18 does not apply in Superior Court. And because 278-18 is the only ability of a judge to continue a case without a finding, without violating the separation of powers, a judge cannot do a continuance without a finding in Superior Court. And I think that...
I'm sorry, are you finished?
Oh, yes.
Could I just ask you about the timing here? As you know, the defendant makes a claim that because the Commonwealth has waited, and essentially you said to Justice Graney that the defendant isn't prepared to accept an entry of guilty he can then withdraw his guilty plea and go through the whole process again. As I understand it, you said, well, we could take it up to the single justice, but the only thing the single justice, not you, but the assistant district attorney, the single justice response, would be, well, when the indictment is dismissed, you can come up on appeal. But it seems to me that the Commonwealth knew at the very moment that that docket entry was made, here you've got a defendant who's been out on 3 years of probation, which is a sentence, and now the Commonwealth, after he has completed that, wants now belatedly, it seems to me, unless you can tell me otherwise, to put the genie back in the box. Why didn't the Commonwealth come right up?
I would suggest that the Commonwealth was following the procedure that was laid out in Commonwealth versus Cheney and cases before that, even I believe Commonwealth versus Brindano.
But if you're saying that what the judge did here is inconsistent with Cheney, right?
Right.
Cheney prohibits what the judge is doing here.
Yes.
Then bring it up.
Because in Commonwealth versus Cheney, it was a pretrial continuance for 6 months. The Commonwealth, as was done there, filed a notice when the judge made a decision of their intent to appeal and then appealed the dismissal. The Commonwealth...
Here, in essence, the Commonwealth is saying, I'm entitled to judgment, right? I'm entitled to judgment. I'm entitled to judgment entering right now, and the judgment is he's pled guilty, and there's got to be a finding of guilty right now.
There was no final judgment until the defendant...
No, I know there's no final judgment, but you were entitled to demand the judgment entered at that point.
It was the Commonwealth's belief that under 211.3, which is an extraordinary remedy,
right,
that where there was this clear alternative right to the appeal from the dismissal of the motion, the appeal from the allowance of the motion to dismiss, that they did not fall within 211.3. Now, this is not your ordinary continuance without a finding or pretrial probation case, whereas the judge in her disposition memorandum clearly anticipated there was going to be another step before the conclusion of this case, was that there were going to be, I believe it was within 60 days or 30 or 60 days of the termination of the probation, that the defendant was to file an affidavit under Brindano and I believe Tim T., and then the case could be dismissed. So there was no final judgment until that time, and there was the clear extra step before the case was to be dismissed. I would also note that this is not a case where the defense was unaware of the Commonwealth's position. The Commonwealth objected at every possible opportunity.
Oh, I saw that. There's no claim of waiver in that sense. It's the due process claim that I'm trying to address.
What I'm curious about is this. If the defendant had violated the probation during this 3-year period of time, would the Commonwealth have moved for violation of probation? Probably. Wouldn't you agree?
Well, I think that would be a matter for the probation department. Would there... I don't know that whether the Commonwealth would have... It seems like if the defendant was on probation, that would be a matter of the probation department, not the Commonwealth.
Well, he's been on probation for 3 years, right?
He was. It was terminated in 2006.
So during that period of time, he was under the terms of probation.
He was.
And
so what do we do with the sentence that he served?
I'm sorry?
What do we do with the sentence that he served?
Well, the Commonwealth would suggest that was pretrial probation. There has never been a valid disposition of the case.
Do you have any objection to the sentence? As I understood in your answer, one of your answers to Justice Craney, you said that all you want is that a guilty finding be entered. You don't want any sentence.
That is correct.
So you're satisfied with probation?
Well, yes, and even in 2003, during this initial proceeding, the Commonwealth did not disagree with a term of 3 years probation. What it disagreed to was not entering a guilty finding on the record.
If he doesn't agree, then the quote sentence that's been served is a nullity, isn't it? Because the procedure was illegal.
the Commonwealth would agree to that. Whether there is ever due process or laws that might come in would be an argument, I think, for a later time.
You're, in essence, what you're arguing, am I stating it right, that somehow the judge managed to avoid the implicit rulings of all our prior cases, and you want us to say that explicitly that this isn't permissible?
Well, I'd like you to say it explicitly, but I don't think, I think looking at it under an implicit analysis is incorrect. I think it is most appropriate to look at it under a separation of powers analysis, which is under the separation of powers, unless there is a legislative enactment providing for an alternative disposition, a Superior Court judge has no authority to continue a case without a finding, to dismiss a case, a legally valid indictment over the Commonwealth's objection, and that's what's happened here.
Haven't we said that before, that you can't dismiss a case over the Commonwealth's objection?
Well, the Commonwealth was just, you said that in Cheney, the defendant.
Well, we said that, it says specifically prior to verdict, finding, or plea.
Right.
You can't dismiss a case prior to verdict, finding, or plea. And the question is whether that extends to these circumstances, I suppose.
Yeah.
Or whether, I mean, I take it your position is Brandano was simply wrongly decided, so any vestiges of Brandano should go.
As to using Brandano as a disposition, that's correct.
Thank you, Ms. Alford.
Thank you.
Mr. Obligato.
If the court please, my name is Carlo Obligato, and I represent Mr. Powell, the appellee. I'll pick up where Justice Cordy ended. We feel that the judge did nothing that is inconsistent with Cheney in this case. In fact, the court was prescient in that it, based on Tim T, using Tim T as its guidepost, Judge Butler in this case saw that what was necessary was that the defendant tender a plea of guilty in this case, and that would then be appropriate. And that's what this court said. You have to have a verdict, finding, or plea. Now, with respect to Justice Spina's question,
But the finding wasn't entered on the record.
well, precisely, you cannot enter it on the record, and this deals with what I pointed out in my reply brief under McCullough and other cases, that once there is a finding, it becomes final and irrevocable. That's what Justice Spina said in McCullough. And that is essentially what Chapter 278, Section 18 recognizes.
So suppose this fellow is filling out a job application, and the question is, have you ever been convicted of a crime? What's the answer to that?
During the period that he was on probation?
No, now.
Or now?
Now.
Now would be no.
Why? He tendered a guilty plea, and it was accepted.
But it was not entered.
Well, doesn't that show the whole fallacy of this procedure?
Well, no, because if we look at what the legislature has done in Chapter 278, Section 18, it says that one can request, and this is over the Commonwealth's objection, that one requests that a guilty finding not be entered, but rather the case be continued without a finding to a specific date thereupon to be dismissed.
That apply to the Superior Court?
That is in the district court.
So.
But this, no.
They obviously didn't intend it to apply to heavy felonies.
Precisely. But this court in Sebastian S. cites Section 278.18 as applicable to the district court, municipal court, and juvenile courts, but then cites Brandano as judicially creating the same sort of procedure. But the gloss that we've put on Brandano is that, as Justice Cordy said, you have to have a verdict, finding, or plea. So in other words, what occurred here was that we mimicked Section 18 by requiring that the defendant tender a plea. You can't have it enter because then it's irrevocable. Yeah. Your only means would be a direct appeal or motion for a new trial.
Would you agree that this case presents the question squarely of whatever's left of Brandano either has to be preserved or has to go? If we rule against you, then it's gone. If we rule for you, there's this little niche situation.
I agree, but thus far this court has never said, it certainly didn't say it in either Cheney or in Sebastian S., that Brandano has been overruled, superseded, or abolished.
That's why I say this case squarely presents the question.
This case does, because as we read it, and when I say we, I'm Mr. Powell, my office, and other Superior Court judges who are still granting continuances without a finding, albeit they are unusual in the Superior Court. But it does occur because the legislature has, as pointed out in Sebastian S., in footnote 9, a long list of offenses where the legislature has explicitly barred a continuance without a finding. We read that as to say, all right, where they have not explicitly barred it, then it is potentially available.
Then how do you read Chapter 278, Section 18? Why doesn't it say Superior Court in there?
Because that is a codification of this procedure. If I may read from Sebastian S., that is the way by which it codified, regularized, and placed limits on a disposition practice that had previously been one of judicial creation. But then the court cites Brandano as judicially creating, not created, not past tense, a practice and procedure for dismissing criminal charges after continuances. So we read that as saying that Brandano lives to the extent that if there is a tender of plea, previously, as pointed out in Cheney, in describing Brandano, you did not have to tender a plea to get a Brandano dismissal. You now have to do that. So this court in Cheney concluded, judicial power does not extend to authorize a judge to dismiss an otherwise legally adequate indictment prior to verdict finding or plea. Previously, you could do so without pleading guilty or admitting to sufficient facts. That's the difference. You can still do what occurred here, the affidavit, the counter affidavit, the hearing, and written findings by the Superior Court judge. And that's what judges have continued to do today.
It seems to me that since Brandano was decided, the legislature has shown a profound distaste for the case by enacting all these statutes that we're talking about that says you can't do it here, can't do it here, can't do it here, can't do it here.
But they haven't said you can't do it anyway.
But it's surplusage if they're doing that and they mean it to apply to every case, and you're saying that it's simply impermissible, then why put that in? The legislature is presumed to know the case law from this court, and reading this case law, it seems to say that as long as there is a tender of plea, it's sufficient.
You can't rely on, what is it, 278-18, you can't rely on that at all.
No.
And I take it that the list of offenses, let me ask this, you sort of struck a chord. The list of offenses that the legislature says cannot be disposed of by reason of a continuing without a finding, I take it includes offenses that clearly couldn't be disposed of in the district court.
So, including indictable offenses. Some of those are indictable offenses. I did the same thing this court did. You go through and look at all of the offenses. They are not simply district court offenses. Not this, to sort of paraphrase, since we're still in an election cycle, Senator Lloyd Benson in the Benson-Quayle 1988 vice presidential debate. I know Commonwealth versus Cheney. I was his counsel. And this is not Cheney. Cheney didn't tender a plea of guilty. And Judge Maria Lopez put him on 6 months probation. And she did so with an offense, rape of a child under 16, which by statute bars a continuance without a finding. That is not the case here at all. So the Commonwealth's reliance on Cheney that this is as controlling this case, I think, is simply inappropriate. Now, with respect to the timeliness, Justice Marshall's question, if you look at Sebastian S., within a month after the court did what it did, the Commonwealth took a 211-3 petition.
But doesn't this record show that you did not have any problems with the Commonwealth coming forward when it did?
Well, the Commonwealth has a right to appeal the dismissal. We acknowledge that. But on the other hand, it filed a notice of appeal from Judge Butler's order, original order. But then it didn't do anything to perfect that appeal. Then several months goes by, Cheney has decided it brings a motion for reconsideration. It files a motion for reconsideration, they lose. Mr. Wilson didn't even bother filing a notice of appeal from that decision. Then they let 3 years go by while the defendant is on probation and does stellar, and then the case is dismissed, and then they bring another motion to reinstate the indictment.
Isn't the answer to that, if we go in the Commonwealth's favor, that he'll be permitted either to have the finding entered, at which point the whole thing is over because they don't want any further sentence, or he can withdraw his tender or his guilty plea, and there'll be a trial, and here's the final piece, and we say in any event, if he's convicted, he can't be sentenced to more than 3 years probation, which he's already finished. So that eliminates any due process problem and everything else. Isn't that the answer to that?
Well, that would be one answer to that, but underlying that, the question, though, however, is that this court can then never dispense mercy in the form of justice. We're talking about in the interests of justice, whether the court can say this person does not deserve a criminal record. Because if you're saying that with the tender of plea there has to be an entry, why must there be an entry in an indictable offense when in the district court under Section 18 you don't have to have an entry?
Because the legislature has said that.
But see, the legislature is also presumed to know the law of this court. And it sees Brandano and says, well, we don't have to do this for the Superior Court, but we are going to codify it in the district court. So you're saying if it's an indictable offense, it has to be a guilty finding, whereas in the district court there need not be.
There's another way to do this, and that is if we agree with your sister, she won't like this, then we say, well, for the future you cannot do this. But because of what occurred here and he served the sentence and due process considerations and all of that, this result stands. How about that?
That would be fine with us, for Mr. Powell, but on the other hand, I still think that this court has to have the potential in situations where the government is, hell-bent on pursuing a case. And let me take a case that's in the news these days, which we all know about, the tragic death of the 8-year-old with the Uzi submachine gun. Let us assume that the father is prosecuted for wanton and reckless conduct. And a judge says, I'm going to let him tender a plea, but the anguish that he is going through, I don't feel that he necessarily has to have a guilty record. And since the legislature has not barred a continuance without a finding for wanton and reckless conduct, that would arguably be an appropriate situation where the court can dispense justice. The Commonwealth is saying, no, once we come up with that indictment, you've got to have a guilty finding. And that is our position. So yes, if this court says from here on in we're going to make what is unclear clear, Brandano is dead, but I don't read that as being the case, and nor do other Superior Court judges. If there are no further questions, I rest on my brief. Thank you.
Thank you, Mr. O'Sullivan.